Good day. My name is Abdullah Al-Mamun. I'm the Deputy Executive Director of the Muslim League of Fund America. As many of you know, the Muslim League of Fund America visits communities all across the country. And we talk about the fact that we fund cases where it's pertinent and related to civil rights, civil liberties, immigration issues, and nonprofit business compliance matters. The way we fund these cases is by funding an organization called the Constitutional Law Center for Muslims in America. Today I'll be sitting down with Christina Jump, who is the Civil Litigation Head, as well as Leila Mustafa, who is the Civil Litigation Staff Attorney, to talk about a very important issue that Muslims all across the country are constantly facing, which is that when they're flying, they are automatically or sometimes told that, hey, you're on a watch list, or sometimes they're not even told because they're being harassed or randomly selected with secondary screenings. So today I wanted to ask Christina, how would someone even know if they're on a watch list?
Well, there are a lot of different ways that people can tell that they're on a watch list. One of the problems that we have with the due process of the whole situation is that nobody receives notice in advance. There's no opportunity where you are accused of being or charged with anything that might put you on the watch list where you have an opportunity to defend yourself prior to being on it. So there's no advance warning, but once you're on any of the watch lists, then you can figure it out pretty quickly by how it begins to affect your life. The simplest and straightforward one is the no-fly list. And the easiest way with that, if you can tell that you're on the no-fly list, would be that you try to make a flight reservation. Maybe you have a flight reservation that you've made, and you've even confirmed it and perhaps even checked in online. And then when you show up to the airport and try to go through screening, you can't. You are stopped, and if that happens, then you may be escorted directly out. You will not be able to make it through the security line at all, and you'll be walked out of the airport. If you are in fact on the no-fly list, you'll be walked out of the airport at that point before you get through screening. It may be as well that you can't print a boarding pass in advance, and you're told to go to a ticket counter. And when you go to the ticket counter, somebody has to make a whole bunch of phone calls, call other people down, and then you're told, well, before you can get through security, you need to call this number and speak with TSA. At that point, you're certainly not making that flight, and you're not making any flight that day. And realistically, you probably are on the no-fly list, even if you haven't been told so. If you're on the secondary screening list, which is the lesser tier watch list, it's a little bit more difficult to tell, but there's still some very clear giveaways. For example, a boarding pass that you print out will have the 4 S's printed on it, which we refer to as quad S, meaning that is secondary screening security selection. And theoretically that's random, but if it continues to happen to you every time you travel, you always have the 4 S's on your boarding pass every time that you travel, and it always takes an excessive amount of time and additional screening for you to get to your gate. That's one way that you would know that you're on a watch list, which puts those 4 S's on your boarding pass.
Is this traveling international or just domestic?
Both.
Okay.
The rules are more strict for traveling internationally, so you may be, for example, for international travel, if you are on the selectee list, the lesser watch list, you will be allowed to travel, but everything will be searched, including probably any electronics that you have. You'll be asked for the passwords. And at the moment, Customs and Border Protection believes that they have given themselves the right, they have written their own regulations, which gives themselves the right to check and to download or make copies of electronic devices. That is one of the topics that we are challenging and pursuing in some of our litigation that we don't believe is appropriate. But domestically, the situations that I described will still happen too. Even if you're going from New York to Chicago, if you're on the no-fly list, you won't be able to do it. And if you are on the selectee list or the lesser watch list, it can be very time-consuming.
I see. Leila, if someone is being harassed like this, their civil rights are obviously being violated, why can't you just sue if you suspect you're on a watch list?
Well, you can eventually sue, but you still have to go through the administrative process that is available. So the Department of Homeland Security has a process called Travelers Redress Inquiry Program. We call it DHS TRIP, it's much shorter. The Department of Homeland Security oversees TSA, the Transportation Security Administration, and that's the agency you encounter the most at the airport. So there is a process in place for any travel difficulties you face, whether you think you're on a watch list or the no-fly list. So you would have to initiate that inquiry. And if you didn't, and you decided, I'm just going to go to court right away, you wouldn't be a successful plaintiff, because a judge would say you have to exhaust all available administrative remedies. They have to give deference to the government agencies. So you could eventually sue if you exhaust that process, but you have to go through it first, even if you want to challenge its sufficiency later.
I see. So I'm assuming that while you're exhausting these efforts, you would need an attorney. So I'm assuming an attorney would make it even better. Why do you think it would be better to challenge a situation like this with an attorney as opposed to just going at it by yourself?
Well, certainly it is, as Leila said, something that individuals can do themselves, but we don't recommend that. We recommend that if somebody knows that they are on a watch list or strongly suspects that and has clear reason to suspect that they do have an attorney assist them with the process. And that should be an attorney who knows this particular process, not an attorney necessarily who focuses on just civil rights or on just any immigration-related issue, because this is not specific as to just as to citizens or just as to those with any kind of a visa or other status. What comes up is that this unique process, administrative process that exists, has a lot of quirks to it. There is no place that the entire DHS trip process that Leila referred to is clearly published and listed, that's readily available for anybody to go look up. Even on their website, what they publish is how to start, how to file a complaint, but they don't tell you what the next steps are or how you can do them or what the time periods are that should happen. And there are several different steps. There are several layers of this. So it's not cohesively printed anywhere. It took us a while, quite frankly, of doing it to figure out what the various steps are and what we are likely to encounter. And now we can anticipate what kind of responses we expect to get, and we know where to stay on top of the agency to hold the agencies to their own published timelines as well, so that they have to provide answers. Also, quite frankly, when your complaint is filed by an attorney or with an attorney's name on it, and particularly an attorney whom the TSA attorneys or the DOJ attorneys have come to know as being somebody who does practice in this area. We have conversations with many of those attorneys on a weekly, if not more often, basis. And when we have that, when we have our name or the name of any attorney who does this regularly attached to a complaint, it quite frankly can get a faster result. It goes in a different pile. We may get a phone call saying, we saw that you just sent this, we saw that you sent a letter threatening legal action if you don't get a response. We want to let you know where we stand on this and when we expect to get you a response. And we may get a phone call like that. Whereas if you file it simply by yourself, it'll sit there until they're forced to do something else. And if you don't know the time periods, if you don't know the process by which to hold the agency accountable, then there's nothing that motivates the agency to give an answer.
Wow, that's very scary as well as informative. Reason why I say that is because I'm assuming that CLCMA takes on some of these sort of cases. Does anyone ever actually get off these watch lists?
Yes, sometimes. We've had several clients that actually have, but there's no way we could promise or guarantee that that would happen, and it really depends on the situation. That's more so for the no-fly list. The watch list is more difficult to challenge because so far they don't even have to say you're on a watch list. Whereas on the no-fly list, they are supposed to at least say, yes, you're on the no-fly list. So it's a lot harder to get someone off the watch list when it's not even acknowledged. We're currently challenging that through a variety of different ways, primarily in the context of employment, where someone works for the airport and their security clearance is revoked, or potentially they're a driver trying to get a credential to be able to access different ports. So that's one way we're challenging the watch list. But when people do receive notification they're on the no-fly list, they are not necessarily told that they were on it before. They're just told currently, you are not on the no-fly list. So even those people that do get off aren't going to necessarily know why they were ever on it. So when people do get off the no-fly list, we usually have them carry that letter around with the Department of Homeland Security logo, because they still are likely to encounter problems when they travel. Even though they can still fly, they're still likely to go through additional security.
I see. What do you see coming in the future in this specific area?
We certainly don't expect this area to go away. There's nothing that we've seen through policies of this administration, through policies that have been issued or regulations that have been issued by the relevant agencies. We haven't seen any indication that they plan to lessen the restrictions in any way, shape, or form. And certainly there are legitimate security interests that do motivate some of the procedures that they have. What we have learned, though, and what we have encountered is that the TSA, the Transportation Security Administration, is now beginning to separate how it responds to even the DHS trip actions that are filed, and even if they're filed by us, depending on the immigration status of the individual who files the trip action. That is not on their website. That is not on their form. There's nothing on there that specifies that they're going to give you a different type of answer or a different quality of answer based on your citizenship status. What they're doing now, though, however, is defining U.S. persons, which is a term that's existed for quite some time, but just has not led to a different result in the DHS trip process until recently. U.S. persons are defined as United States citizens or lawful permanent residents, what used to formerly be referred to as green card holders. So those categories get the assurances, as Leila mentioned, of being told that you are or are not on the no-fly list and having the opportunity to seek the supporting information why. Again, that is still a slow and tedious process that has to be done the right way, but it is possible to get that, and the government acknowledges that individuals who are U.S. persons, citizens or LPR holders, are entitled to that information. Currently, though, they're not necessarily recognizing that the same process applies or that the same amount of entitlement to information is available to anybody who is not a U.S. citizen or an LPR holder. So even if somebody is here legitimately, say on a student visa, or on a work visa, they will not necessarily be told yes, they are on the no-fly list or no, they are not, or given the opportunity to find the additional information. We also have found out through some of our recent charges that we filed and conversations that we've had in this area that a lot more additional information is now being requested of the non-citizens and non-LPR holders who want to appeal the determinations that they are given and who want to try to get additional information. According to TSA, they are required to give extensive and we believe overly burdensome information along with their application in order to figure that out. And that's not the purpose of the DHS TRIP program. That's not the reason for which it was created. It was created as a traveler redress program to find out why you are having difficulties relating to traveling. Again, that does not have anything to do with a lot of the invasive questions, and we believe way too broad and non-relevant questions that TSA is now requiring that anyone who is not a citizen or an LPR holder provide in order to even get the most basic of substantive answers. So we plan to challenge that, and we have some matters and some clients where we are attacking that. We are also now seeing as well that placement on any one of these watch lists can affect other rights. One of the more readily available ones or readily visible ones can be getting a security card, as Leila mentioned, for employment, or getting an access card to work at an airport. But we're also seeing it, for example, in firearms purchase. And there is no statute that has ever been passed in Congress of no fly, no buy, despite them being introduced repeatedly. But we have seen with several clients, and we are challenging in the courts right now, that even though there is no statutory authority and no authority that Congress has granted to the FBI or to the TSA to prevent someone from buying a gun because of placement on the watch list for whatever unknown reason, what's actually happening is that those purchases are being delayed. And in some situations, additional information is being given to the seller at the store, which should not be provided, and which therefore, at a minimum, has a chilling effect and makes it so that those sellers don't want to provide that, don't want to complete that sale, because they think that they'll end up being in trouble if they complete that sale, even though the individual is otherwise completely qualified and able and should be able to purchase a firearm like anyone else.
Wow, that affects a lot of rights. I didn't even realize that not only does it involve your travel, your employment, as well as other rights that you and I take for granted. So thank you for explaining all this. I really appreciate it. And thank you all for watching. If you need help, or if you're facing any issues in regards to the travel situation, or if you're on the watch list, please get in touch with CLCMA by visiting their website, www.clcma.org. And if you like the work that the Muslim League of America does, please visit our website by visiting www.mlfa.org. Thank you so much. Good day.